My guest today is attorney Patrick Burton. He's with the DeMasi Burton law firm here in Orlando. So, Patrick, there are some new laws in place, and we're going to focus on those. And those laws just went into play July 1 of this year.
That's right. There's been a handful of them.
So let's pick one that you find to be interesting, or you know, affects a lot of people within HOA communities.
Sure. I think the one that we probably get the most questions on has to do with parking.
Let's start with saying this, that I get people that email me all the time saying, Tom, I got a work truck. I'm parking my work truck in my driveway. The HOA is even telling me I cannot do that, for example. So we're prior to July 1 of this year, things might have been loosey-goosey, just however, whatever HOA board, whatever rules they want to devise. Now something new has happened.
That's exactly right. So what we really saw come out of the legislation this year was examples of the state kind of controlling a lot of the flexibility that associations used to have. And commercial vehicles are a great example of that. So previously, associations had the ability to define what a commercial vehicle is. If you've got a logo on it, you've got a ladder on it, if they want to say that's a commercial vehicle, then it's a commercial vehicle, and they can say you can't have it. However, with the new statute in play, the statute says that associations no longer get to define for themselves what a commercial vehicle is. Congress in the state of Florida, they decide what a commercial vehicle is, and they've defined it as a vehicle that weighs over 26,000 pounds or has more than 2 axles. So 26,000 pounds is a ton. Well, it's a lot more. It's multiple tons, actually. It's a lot of weight. A school bus typically doesn't weigh 26,000 pounds. So what we're saying here is that pretty much any vehicle that would normally be used by anyone other than maybe a cement mixer is probably not going to be a commercial vehicle anymore, and the association has lost the ability to tell owners that they can't have that vehicle in their driveways.
Once you get up to that kind of weight, though, generally you're going to be moving from a 2-axle vehicle to a 3-axle vehicle, so that might be a more accurate way to describe what the limitations are.
Sure, absolutely.
So before, when I'd have people contact me, they say, Tom, I'm putting my truck in my driveway. They're not even letting me do that. You're saying now if it's under $26,000 and less than 2 axles, they can park it in a driveway, or they can park it on the street if they want to.
That's exactly right. They can park it on the street if it is a public street. If it is a private street owned by the association, typically that would be like a gated community. That would be an example of a private street. Associations can still control what happens on those, but if it's a public street, the same rules apply. If it's not more than 2 axles or 26,000 pounds, it's not a commercial vehicle and you can have it there.
Most HOA communities are not gated communities. I'm going to make that assumption, right? Now, then they have public roads running through those non-gated communities. An HOA building doesn't necessarily have public roads running through it, does it?
No. So when you're talking about the distinction between an HOA and a condo.
Okay.
So the homeowners association, they have common areas that they own, and then they have the legal right to tell you what you can and can't do on your lot, on your property. Condo associations, there's no portion of the condo that is owned by or dedicated to a municipality or a county. So every aspect of what's going on in a condo association, the association has some level of control over what's happening in it.
All right, let's go